Good morning. Happy Friday. Happy Veterans Day, and thank you to all veterans who've served. Today's been a bit crazy. I haven't read these yet. These appear to be identical motions. The first one is 18 pages, the second one is 12 pages. I don't know what the difference is yet. I have not read them. I have seen people discussing them on my Discord channel, but I have not read them, so I'm going through this a bit blind. So these were filed in the Decastro versus Abrams et al. Case. This is entitled, they're both entitled, A Motion to Correct the Record or Alternatively to Reconsider the Motion to Transfer Venue and also Preliminary Injunction. So it appears to be, from the way he's phrased this, there's going to be a motion to correct the record or, in the alternative, a motion to reconsider. And then, in addition to one of those two, there's going to be a motion for a preliminary injunction. It doesn't say to what, but okay. Motion to correct record or alternatively to reconsider motion to transfer venue, preliminary injunction. I, Jose Decastro, plaintiff, hereby moves this honorable court to correct its record under Federal Rules of Procedure 60A. 60A. I was not expecting this. Corrections based on clerical mistakes, oversights, and omissions. The court may correct a clerical mistake or a mistake arising from an oversight or omission whenever one is found in a judgment order or other part of the record. The court may do so on motion or on its own, with or without notice, but after an appeal has been docketed in the appellate court, and while it's pending, such a mistake may be corrected only with the appellate court's leave. Now, what that is saying is that is going to correct a mistake that the court or the clerks of the court made. That is not to correct a mistake that Chile made. It's my understanding that Chile has already alleged that he somehow failed to file the notice of withdrawal already. So now he's apparently saying that it was a mistake the clerk made. Now, I don't file in federal court. I may have done it once, but normally we hand it to a gal, a paralegal, who does those filings. And the only way I know that it's been filing is there's an email that gets spat back into my email account some short time later saying that there's been a filing. So my best understanding, at least at the way, I don't know if there's a difference between the way a pro per does it and the way a law office does it, but my best understanding is that if you're an attorney or somebody at a law office and you file it, you get to pick all the things and how it goes in. Again, that's not something that attorneys at any of the law offices I work at do. So I'm not entirely 100% on this. If I remember correctly, the one time I did have to do a filing in ECF, it was in bankruptcy court. And I don't really remember doing that. That was years ago. And it was a one-time deal that I think I did it. And I just don't remember it. And there also might be differences based on the amount of time that's changed. And there might be a difference between the way bankruptcy court filings work and non-bankruptcy court. So I just don't know. But I don't think he's going to get too far on this. If he can show in his pleadings that the clerk made the mistake, sure. But normally something like this is like if the court enters a judgment, you've proved your case for $62,000 in damages, and the court, through a clerical error, awards you $6,200 in damages. You could submit a motion to correct the clerical mistake because the court was supposed to enter $62,000. The court said $62,000, but at the end, they just left off a zero. That's kind of what this is more designed to do. It's designed to correct a mistake that the court made or that a clerk made, not in correcting a mistake in what a filer did in ECF. That's my best understanding of it. And to and record the plaintiff's voluntarily dismissal. Okay. So I believe it has been recorded. I believe the voluntary dismissal was this. Recorded. Actually, that's the wrong word. So you record things at the county recorder. That'd be things that go, not, you file in court, you record at a county recorder. So like you record a deed, you file a motion. There are different terms for different things. So I don't know what, I'm assuming that he means to file it, but it was filed. It was filed. The court just did not, according to the court lacked the jurisdiction to grant it. According to the court, once the defendants filed their answers, the court lacked the power to dismiss it with a notice of voluntary dismissal. So that's where we're at on that. As filed before defendant's answers to my complaint, which is true and in the interest of justice. Well, we're going to see, I guess, if he actually makes any sort of showing that it is in the interest of justice. In the alternative, to reconsider my motion to transfer venue and move for preliminary injunction. What is the preliminary injunction? We'll find out, I guess. He doesn't state what he wants the preliminary injunction to be. So again, this would be a good time, I guess, to go over Ahmed versus Rosenblatt, a First Circuit Court of Appeals case, pro se leniency. Finally, Ahmed, who is the pro se litigant, contends that he should have been accorded greater leniency due to his pro se status. Our judicial system zealously guards the attempts of pro se litigants on their own behalf. We're required to construe liberally a pro se complaint and may affirm its dismissal only if a plaintiff cannot prove any set of facts entitling him or her to relief. However, pro se status does not insulate a party from complying with procedural and substantive law. The policy behind affording pro se plaintiffs a liberal interpretation is that if they present sufficient facts, the court may intuit the correct cause of action, even if it was imperfectly pled. This is distinct from the case at hand, blah, 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 in which formal elements of the claim were stated without the requisite supporting facts. So we're looking for him to plead facts at this point to get what he needs. And he hasn't stated what he wants as a preliminary injunction, so we're going to be looking for facts in here to suggest what preliminary injunction he is requesting. Under FRCP 41A1A subdivision I, plaintiff has an absolute right to dismiss an action that has been brought before the opposing party serves either an answer or a motion for summary judgment. That's correct. He says, I filed a notice of voluntary dismissal prior to being served with answers or motions for summary judgment. He did not. He attempted to file it at best. There was an apparent error that I am completely not at fault for. Oh, Lord. Okay. For which the court is responsible for investigating and resolving in the interest of judgment. Citation fucking needed. The court doesn't appear to have made an investigation, so I'm moving the court to do so. Courts do not investigate. Courts don't investigate. Courts do not investigate. I can't say this any more clear than courts do not investigate. It is the duty of the parties, the moving party, to present facts sufficient to the court for the court to be able to make a informed decision. And if the moving party fails their burden, if they fail to present those facts to the court has zero independent obligation to conduct an investigation. And in fact, it is probably error for the court to do so, reversible error for the court to do so. That is the role of a judge of the court. The court is the judge is the court. The role of the court is to determine what the facts are based on the facts presented by each party. That's it. There's no investigatory role of the court. Period. End of discussion. Zero. The court has said that I did not explain why I did not refile the document until it appeared. That is correct. You did not refile the document until it appeared. I was never notified that filings would immediately appear in the electronic record, and in fact, my experience was the opposite. I've never seen it take, well, I've never timed it. You hand it to the gal who's going to do the filing, and then I'm guessing it's a very short time later, within minutes, if not hours later. It certainly doesn't take days later. Now, I'm not suggesting by any stretch of the imagination that there couldn't be some sort of a hiccup, because I've never, again, filed pro se in federal court, never done it, don't know the process. But there should have been an explanation given ECF filing for pro se plaintiffs. This doesn't say how long it takes. So I don't know how long it takes for pro se litigants, but I'm assuming that you get some sort of a receipt for it, that you get something back saying that something has been filed or that they've received your filing. I don't know if the clerks review these things. That's where I'm going. I don't know if it's the same steps for a pro se litigant as it is for an attorney. I just know that when attorneys file it, it generally speaking pops up almost instantly, if not instantly. I've previously e-filed documents where I was notified that it was too late to file and the documents would be filed later. Yeah, you have until midnight, I think. So the question is, did you get the notification on this one? So he previously got this notification, the documents would be filed later, but did you get it this time? I expected the NVD, that's the notice of voluntary dismissal, to appear on Monday, and was surprised when the defendant's documents that had been filed after mine showed up before mine. So did you notify the court? Oh, there's my name. Did you notify the court at that time that there had been an error? Because Monday was the 7th. Monday was the 7th. So did you notify the court at the time you saw the filings by opposing counsel? Did you notify the court at that time? Non-party attorney John Rietveld, that's me, I'm internet famous, bitch, who had been reporting on this case, even made a video suggesting his followers. I have followers now. I have followers. I disavow followers. I might have subscribers to my channel, and that's it. I do not have followers. So that's wrong. You're a liar, Chili, and you suck. I do not have followers. I have at best subscribers. And I don't even think that I get, yeah, so it is subscribe. What's the paid one? I don't have the paid one, whatever that is. Where are we at? Who's been reporting on this case, even made a video suggesting his followers wait until the dust settled, that clerks don't typically work on the weekend, and it might take some time to file all the documents, and that they might not appear in order. Yes. I suggested that to my followers. I don't know if I put this in a video or if I said it on my Discord, but somebody asked me, or I addressed this issue. I think it was on Discord. The more time you delay, the less likely it is that the court is going to grant you your relief based on mistake or inadvertence or excusable neglect. So I would always advise, or I would always, if I was the filing attorney, the moment I noticed other people's filings popping up before mine that were filed after mine, I would immediately attempt to rectify the situation. I would be on the phone with the clerk, seeing if my paperwork was in the queue. I would be preparing a motion to, set aside any particular orders or whatever based on excusable neglect. I would be going out of my way to make sure that shit got taken care of ASAP. If you sit on your laurels just waiting for time to pass, you undermine the credibility of your statement. So what I suggested to my followers, that they relax and just hold their horses and wait for the dust to settle, is not the advice I would give to a pro se litigant. It's not the advice I would have given to Chili. If I was giving advice to Chili, if I was on his legal team, I'd have been, hey, bucko, you best get this shit solved. You better get on the horn with somebody. You need to get this resolved. You need to send your little letters or whatever dumb shit you're going to do, because if you don't, the longer you take, the less likely it is the court's going to grant you the relief you want. But you've made me even more internet famous now, Chili, so thank you. You know, it's funny. It's funny. All these guys say they don't watch me. I have the best hate watchers. I have the best hate watchers. Imagine if I could use a Donald Trump impersonation, it would be, I have the best hate watchers. If I could do it, I would totally do it right now. But I can't do a Donald Trump impression, so you just have to imagine it. And no, I don't want to make my channel about politics. That was a joke. Relax, everybody. Whether you're for or against him, just relax. I don't care. I say this simply to point out that I am not the only person that thought this was how e-filing worked. I didn't say that was how e-filing worked. I suggested that there might be some sort of an issue. I didn't say that that's not how it worked, Chili. And just because some non-party attorney who's reporting on it, I mean, I am a first-year family law attorney. I don't think the court is going to take what I say into consideration. If I had known that a document didn't immediately appear, that I needed to keep filing until it did, I would have followed that process. Well, here's your clue there, buddy. Your clue was that the two attorneys each filed on the 7th, and it appeared the same day. That's your clue. That's your clue that nothing's stuck in the pipeline. I also believe that we would have had many duplicate documents filed due to the delays I have witnessed in the past. But again, did you get the notice that your document would be filed later? That it was too late to file and the document would be filed later. I apologize. I should have had this bigger. See, I had previously filed documents. I was notified it was too late and the document would be filed later. Did you get that? You still haven't alleged that you got that. You're making excuses now. You're not giving facts. I'm requesting an evidentiary hearing to bring witnesses as to how a reasonable person might expect e-filing to work, as well as to talk to your IT people after they've investigated and to discover electronic evidence of my submittal. That's not happening. I'm just going to go out on a limb here, and I'm a non-party attorney who's just reporting on the case, but I'm going to say that's not happening. The court does not need you to bring witnesses as to how a reasonable person might expect e-filing to work, because you have allegedly gone through the class and you have been able to e-file and you have received notices in the past on some, but not all of your filings where it was too late to file and a document would be filed later. So that's not going to help you. Even if the court allowed you to bring these witnesses on, it would not help you. And you're not going to get to the court's IT people. They're going to be like, if the court asks them, which the court will not do, but like if the clerk asks them, hey, is there any way that this could have been an F up on our end? They're going to say, no, it's filer error. And that's going to be the end of it. I'm calling it, obviously I don't have any personal knowledge of it, but take that to the bank. He's not getting any of the relief based on the court's IT people effing it up. There are hundreds, if not thousands, of documents filed every day in federal district court. Hundreds, if not thousands, filed every day. And you're thinking that yours was like magically the one that got screwed up on the IT department side, but everybody else's went through in the same case? That's kind of weird, isn't it? The court has said I submitted no evidence to show that I drafted my NVD before the NEF of the answers. Notice of electronic filing of the answers, I'm guessing. I declare that I did. See, you submitted, past tense. Now you're going to try to submit evidence that you had and you failed to submit. Now, normally courts take a very dim view of this. Courts normally take a very dim view of this. You get essentially one bite at the apple. And if you don't show all of your argument and all of your evidence for getting your way, it's not the court's problem. It's not the court's problem. Now, excusable neglect, let's say you said that there was an attachment, but you forgot to file it with your motion. That would be one thing. But you not putting the declaration not saying in your letter that I drafted my notice of voluntary dismissal and I attempted to submit it, and here's the evidence to show that I attempted to submit it. That's not going to do anything for you. You got to do that the first time. Because if the court allows this kind of thing where, I didn't give you all the evidence, here's more evidence, then you could have 2, 3, 4, 5, 6 motions on the thing. No, you've got one bite at the apple. You need to present all of your evidence and all of your argument at that time. So you're coming to the party late. I don't see this being very helpful for you. In Exhibit 2, I submit to you metadata from my computer showing my submission of the e-file, showing the submission of the e-file. I have glanced through the exhibits, but I did not see anything showing a submission of the e-file, although your IT department likely has better data. I collected this metadata, and it is a true and correct copy. I think this is supposed to be capitalized. I don't think it's part of the same sentence. A YouTube video that I published that began streaming at November 6, 2022, titled in part Lawsuits Are Withdrawn, published there. I collected this metadata and is a true and correct copy. Defendant Catherine Peter published a YouTube video that began streaming at November 7th, 2022, titled in part Chili's Sad Breakup, published there. And in the video, Peter says, I know why you're all here right now. I do. You're thinking that we're going to have some sort of big update. None whatsoever. I'm treating it as as of right now, 9:03 p.m. on Sunday, the 6th of November, I am still being sued and I am treating it as such. Wow. That was a stunning admission by Peter that she still is under the impression that she's being sued. Stunning admission. Boy, you nailed it with that one. I collected the metadata and transcribed this, and is true and correct. In Exhibit 3, I include email notices, including the notice of voluntary dismissal, sent to the opposition prior to the notice of electronic filing of the answers, which I prepared and is a true and correct copy. Okay, so he emailed them, but he didn't file it. And if you file it, there's an automatic, if you're part of ECF, it serves the opposing party. So they weren't served through ECF, so I don't know how much use that's going to be. In Exhibit 4, I included an email reply from Defendant Abrams' attorney of record replying to the email to show proof of delivery. I prepared this document as a true and correct copy. I wonder what the email from Defendant Abrams' attorney is, because Defendant Abrams' attorney, if I remember correctly, was first to the gate to file an answer. So that would tend to indicate that Defendant Abrams' attorney did not think that a notice of voluntary dismissal had been filed. And remember, Rule 41 requires the notice of voluntary dismissal to be filed, not served, but filed before an answer in order for it to be effective. It has to be filed. It wasn't filed. That's your problem. You say, I served it. Doesn't matter. It doesn't change anything. You can serve it all day long. It has to be filed. The court even says that that's a jurisdictional limitation. It has to be filed. As soon as those answers are filed, the court lacks the power to dismiss it based on your notice of voluntary dismissal. I also submit the defendant's answers in the record at number 53 and number 54, which were obviously hastily prepared. Obviously. Okay. Define hastily. Define hastily. Because nothing that I saw in those would have been done within less than an hour. Maybe 2 hours. Maybe more. I mean, there's always lag and bullshit because you got to send it to the client and have the client review it. The client will send it back, usually with requests to change things. So first you draft it, then you send it to the client. The client reviews it. If there are any changes, then they'll notify you. You got to change it, send it back. They have to okay it, and then you can file it. So people complain about big legal bills, but if you're billing like $500 an hour, it's going to take you at least an hour, if not more, to draft even just something as simple as a denial and a counterclaim. Just so you know, if I stumble on those, California only has cross complaints. Only. California has eliminated the counterclaim. Federal courts maintain the distinction between counterclaims and cross complaints. So if I call a counterclaim a cross complaint, that's just because I'm much more used to dealing with the state court than I am the federal court. They both offer permissive countercomplaints. Actually, that's counterclaims. But that's fine. I mean, I get it wrong too. So, I can't really nitpick too hard, although mine isn't in writing. Mine is just me talking off the top of my head. They both offer permissive counterclaims that contain state claims. Well, yeah, your claims are all state claims. Do not establish jurisdiction or authority for relief. Well, they don't have to. They don't have to. They are permissive, as you said, and the court can infer that permission. It's a counterclaim. They don't have to establish the initial jurisdiction that the court would have. Offer anything other than general denial. Well, that's all they have to offer. Either the defendant attorneys have suddenly gotten dumb. You shouldn't accuse people of getting dumb. Gotten dumb. Ooh, that just irritates me. Or these were hastily prepared, which I offer as evidence as to their notice of dismissal, which I offer as evidence as to their notice. They did not file notice of dismissal. Am I lost? Hold on a second. Which offers. And their obvious desire to try to beat me in a race of time to file, which they obviously won due to their continued exercise. So I don't know if anybody remembers this, but Kate and Josh had requested extensions of time to file their answers. And the court had given them until November 7th to file their answers. And so they filed on November 7th. And somehow this is evidence that that they were in a race of time to file against Chile. That doesn't make a fucking lick of sense to me, but okay. All right, so we're going to try this sentence again. This sentence right here. Either the defendant attorneys have suddenly gotten dumb, or these were hastily prepared, which I offer as evidence to their notice of dismissal and their obvious desire to try to beat me in a race of time to file, which they obviously won due to their continued exercise of their position and manipulation of this court that is prejudicial against me, and to keep their claims in the court where they continue to exercise that position. That is possibly the world's shittiest sentence. The first things that I would do to change it is take out obvious and obviously and put in patent and patently, because according to my audience, that would make this a stellar sentence. I digress. But anyway, that's a really shit sentence. And I don't know what it means, and I'm not going to waste the time to try to figure it out. Further, when I filed my motion to transfer venue, the MTV, the court suggested that I dismiss this case instead. Sure, but that doesn't mean you did it. Although I considered asking this court to reconsider my MTV, it seemed more proper to file the dismissal instead of questioning the court's legal analysis. Yeah, courts really like it when you question their legal analysis. Yeah, I'm a 20-year law scholar. I know what to do. I know better than a judge. The series of events in context makes it obvious to expect that an NVD was my next move. Yes, but did you file it before they answered? Finally, I have a text message chain between me and my legal team. Ooh, we're going to get a text message between you. I didn't see that down there. I glanced at the attachments. I didn't see this. This will be fun. I have a text message chain between me and my legal team where we discuss NVD strategy, the preparation of the NVD, and the successful filing of it, which I will submit in the evidentiary hearing or in my reconsideration of this motion. You know what's fun? He has just alleged that this text message chain exists. So now it exists. And so what Kate and or Josh can do in discovery is request production of this text message chain. Now, if this was a text message chain between Chile and his attorney, he does not have an attorney, he has a legal team, but if it was between him and his attorney, there would be attorney-client privilege. But it's not. It's between him and his legal team. Zero attorney-client privilege. He's going to have to fork this over. You're stupid, Chile. You should never have mentioned it. And if you delete it, now that is spoliation of evidence. You've alleged its existence. And if you don't turn it over when they demand it in discovery, which I'm sure they will, you're stupid. You are so many levels of stupid. God, it hurts how stupid you are. I have raised concerns in my MTV, but you replaced my valid complaints with the assumption of a change of hearts. Ooh. Oh, now you're casting aspersions at the court. You're saying the court is so stupid that the court didn't recognize your complaints were valid. First of all, are they complaints? And you saying that they're valid doesn't mean they are. I read your motion to transfer venue, and you made bare allegations that were completely unsupported by fact. Completely unsupported by fact. It was, in legal jargon, shit. It was pure, unadulterated shit. Your motion sucked, Chile. And that's why the court denied it without even argument from the other side, without even a response from the other side. That's how shit it was. And the fact that you still don't understand that means you're destined to get effed in the a-hole, sir. You might even enjoy it. The fact that I didn't know that it was my right to file this action in California, and as soon as I learned that and realized how difficult it would be to bring this to trial due to witnesses and parties being in California, I attempted to move it. Well, you're assuming that you have a right to file it in California, which I disagree. I don't believe that California has personal jurisdiction over the defendants. And you should have figured that out before you filed, dude. That's like a classic you mistake. Although I understand you're reading the motion in the light most favorable to the non-moving party, I ask this court to reconsider the MTV. That's going to get you all sorts of nowhere. That's all sorts of nowhere. You're not alleging any new facts. You're not alleging any new law. You're not alleging anything that would give the court reason to reconsider its motion. Basically, you're just telling the court, I think you're stupid. I think your legal analysis sucked. So I want you to go through the legal analysis again because I think you did it wrong. And you're not going to win on that. You're not going to win on that. The court is simply going to deny this motion. I guarantee it. The court's going to deny the motion to reconsider. What else do we have? We have the motion to correct record. I'm thinking the court's going to deny that too. So we're just going to have to get to the preliminary injunction. In the defamation video by defendant Peter. Oh, in the defamation video. Oh, okay. She cites judicial record in Los Angeles County and alleges to having spoken to witnesses in the same county. Yes, Los Angeles County is not Southern District of California. So you're still not alleging. First of all, you should have alleged that in the initial motion. In your initial motion to transfer venue, you should have alleged that. You knew it, you didn't allege it, you suck and you fail. Second, even if you had alleged it, it doesn't establish Southern District of California. It establishes Central District of California, possibly. And not a good possibility, but just a very slim possibility that would somehow be enough to justify a transfer of venue to the Central District. So you asked for the wrong district and you withheld evidence or withheld allegations that, if true, would have supported your motion. I've given YouTube 14-day notice of intent to sue, and when I add them to this complaint, this case will no longer be diverse. So how would transferring it to the Southern District, or let's just assume arguendo Central District of California, help? How would that help? If you transferred it to the federal court in California, it's still based on diversity jurisdiction. The whole reason why you're in federal court is based on diversity jurisdiction. I don't expect YouTube to stipulate to this remaining in this district. They wouldn't have a choice. They don't have to. But I'm sure YouTube will be very competent in filing a 12B6 based on Section 230A, whatever it was, the Online Publication Act. I forget what it's called, but Section 230, I think. Of the Communications Decency Act. So they'll file a 12B6 based on the Communications Section 230 of the Communications Decency Act, and they'll be kicked out of Massachusetts District Court or any district court that you choose to file it in faster than you can turn your head and spit. Since YouTube did not enforce or did not keep their promise to enforce policies, I believe they are partially responsible for some of the damages under a claim of promissory estoppel. Promissory estoppel is where somebody induces you to do something or not do something based on a promise that they made you. Like if they say, I'm going to give you $1 million, and so then you quit your job or something like that, you could try to sue them for the $1 million based on promissory estoppel. I could be wrong on that, but that's my best understanding of it. Let's look it up. Let's look it up. Contract law. Okay. The doctor or party may not recover on the basis of promise may recover on the basis of a promise made when the party's reliance on that promise was reasonable and the party attempted to recover detrimentally relied on that promise. I'm not entirely sure how this would apply to YouTube, and I don't think you've entered into a contractual relationship with them where you can enforce or you can sue them for the enforcement of their or non-enforcement of their policies. I'm just going to go with that. Not including them will prejudice the defendants. Not including YouTube will prejudice the defendants. I'm sure he's going to provide us some facts to support that assertion. But I don't think including them or not including them will have any impact on the defendants because, again, YouTube's just going to 12b6 and be gone. And the court will grant their 12b6. Additionally, I am obviously, God, I hate that. Like, it's not obvious. If you have to tell the court it's obvious, it's not obvious. If it is obvious, you don't have to tell the court it's obvious. So if you find yourself saying something is obvious, you're doing something wrong and you should stop. Additionally, I am being prejudiced when participating in this court. Why? Why? How? What facts are you going to allege? You're capable of filing ECF. What facts are you going to allege? And if it's just witnesses and appearing at trial, well, if you transfer it to the Central District of California, you're just shifting the burden to Kate and Josh because they're going to have to fly witnesses from Massachusetts and they're going to have to fly from Massachusetts to appear at trial. So, like, I don't understand why you think that you're prejudiced. I'm a pro se plaintiff that should be granted some leeway, which we went over, in the interest of justice, and is obvious. The defendants took advantage of notice of my NVD to try to sneak in completely unfinished answers and counter complaints. They seem to be completed. Now, I quibbled and nitpicked with them, but they were legally sufficient in my estimation to put plaintiff on notice, put plaintiff on notice of the counterclaims against him, and I think it was fine. I think they were fine. Again, my analysis of them was nitpicky, but that was it. I think they were fine. I think they'll hold up. I am being prejudiced due to the error by the electronic filing system, and the defendants are gaining unfair advantage. So first of all, the defendants filed their answers on the date they were supposed to file, by the date they were supposed to file. They were supposed to file them by November 7th. So them actually waiting until November 7th instead of filing it on the 5th or 4th or 3rd or 1st or October. They waited until essentially the last day they waited till the last day to file. Technically, they could have waited until I think midnight, but they waited until the last day to file. And you're saying that somehow prejudiced you? That them waiting to file till the last day to file prejudiced you? That is stupid. I don't know what you think you're arguing, but that's stupid. I'm being prejudiced due to the error by the electronic filing system. Again, you've shown nothing to support that. And defendants are gaining an unfair advantage by filing their answers on the day their answers are due. Dumb. This is not the first time I've been prejudiced against. What does that even mean? What does that sentence mean? This is not the first time I've been prejudiced against. An affidavit that I had couriered to the court last month has still not been filed. No one cares about your affidavit. No one cares about it. The clerk has not responded to my inquiries into it. So you're going to have to say, like, how did that prejudice you? How did this affidavit prejudice you? What motion did it apply to? What purpose was this affidavit to fill? Oh, you don't say? You just say that there was an affidavit? What courier did you have courier it? Do you have receipts for it? What do you have to show this? Anything? Nothing? Oh, okay. Sorry, I'm getting frustrated. Just the level of stupidity here is just driving me nuts, and I'm only on page 5 out of 18, so I need to, slow it down, I guess. The clerk still has not responded to my inquiries into what format to submit videos for the court's review. The court doesn't review your videos, you dumb shit. And also I want to point out that up here, you provided links to videos. Oh, look. Just provide links to them, dude. Put them up on your YouTube page. Put them as private with only people with the links can access, and send it to the court. Documents that I filed don't always show up, and the defendants always seem to get their documents filed first. Oh, the defendants file their documents what we like to call the correct way, so those always seem to show up first. Oh my. To me, it looks like either magic, the court is colluding. Oh, Jesus fucking Christ. I would like to apologize for taking the Lord's name in vain for those of you Christians out there, or whatever. But, oh, have mercy. Magic or collusion? I have a palpable headache from reading this. Magic or collusion? The court and or the clerks are colluding with the defendants. The whole world's against Chile, don't you know? It's nothing that Chile did. It's just that the world is against Chile. Chile doesn't stop. He's got a can-do attitude, and the world is just all out to get him. It's just Chile versus the world. For no reason whatsoever. Can't figure it out. Just the world's just prejudiced against Chile. I will take the necessary actions to preserve my right to appeal any action that interferes with my absolute right to dismiss. Oh my God. So assuming that the district court certifies an interlocutory appeal, assuming you can appeal this right now, you would be appealing this motion and this motion is shit. This motion is absolute shit. And so even if you did appeal it, the level of review would be abuse of discretion. Did the court abuse its discretion in determining the response to it the way it determined? And I have a sneaking suspicion that the court is going to deny at least the first two things that he has requested. The preliminary injunction is still out there. I don't know what he's requested on that yet, but the motion to correct record, or alternatively the motion to reconsider the motion to transfer venue, will both be correctly decided if they're denied. And the underlying denial of the motion to transfer venue was absolutely correctly decided. So, and the motion to correct the record, the court has already essentially treated his letter as a motion to enter the dismissal or whatever, and the court made findings of fact in that. And an appeals court is not going to disturb those findings of fact unless they're completely unreasonable, unless the court has gone completely outside the bounds of reason in determining those facts. And I don't think the court did at all. So good luck. I'm just saying, good luck. You don't have an absolute right to dismiss. Proceeding while preserving my appeal to voluntary dismissal. Preserving my appeal to voluntary dismissal due to error by the court and against pro se plaintiff will give me advantage if I lose on the merits. No, it won't. No, it won't. Your appeal is shit. And yeah, good luck. So now he's going to argue the underlying merits of the case, I guess. At least one clear case of defamation per se is a story published by Peters on YouTube. Now, defamation per se is great. Let's just say that under the California laws on defamation, that selling the date rape drug is defamation per se. Let's just assume that. She still has the defense of the truth. So we have not gotten to the proof of it yet. We have to get to the proof of it yet before we can say it's a clear case. And again, I guess he's supposed to say a patent case of defamation or a case of patent defamation. But no, it's the same issue. If it's clear, you don't have to tell the court. If it's not clear, then telling the court won't make it clear. The title itself is actionable libel. And Peter, and also you have to show, well, I guess if it's if it is defamation per se, and I'm not saying it is or isn't at this point, but if it is defamation per se, then you don't have to show damages, but you might only be entitled to nominal damage, i.e. $1. So in order to get more than that, you're going to have to show actual damages. And Peter clearly shows in the video accompanying the story that it is not true. Well, again, we have another clearly, and we don't know whether it's true or not. The proof comes at trial. The alleged judicial record that she admits is not from a reliable source, and in fact is not a judicial record, shows an arrest, not a conviction, and not the date rape drug, which is Rohypnol, aka roofie. Okay. She still gets to show that it's a judicial record. She gets to show that. It doesn't matter if it's not from a reliable source. And what is a reliable source, Chili? Are you a reliable source? Am I a reliable source? By what metric do you determine what a reliable source is? Again, he says things that sound like facts to him, but they're not. It's an assertion. Did Kate actually say this is not from a reliable source? Did Kate say this is in fact not a judicial record? And does it show alternative sentencing? Just because there's not a conviction doesn't mean that there wasn't some form of admission of guilt. Like if you accept pretrial sentencing, you don't have to admit guilt or innocence, but you also didn't get found to be not guilty. And it also wasn't dismissed. Well, I guess technically it would be, because if you complete the terms of the pretrial diversion, then it would be dismissed. But you get what I'm saying. It's not the same thing as actually having them just dismiss it, or you being shown to, or them failing to show that you're guilty, you being found not guilty. I transcribed this metadata from my computer as a true and correct copy. Congratulations. Due to my likelihood to win this on the merits, I request a preliminary injunction for the removal of the aforementioned story. Why does he say aforementioned? I am just not familiar with that. British English, I guess. Okay. So, Chili's now British English. And it's accompanying video from public availability as well as protection from further defamatory statements. You haven't shown likelihood to win on the merits, but okay. You also have to show that monetary damages won't suffice. So that'll be interesting. Oh, by the way, one other thing is you can't defame someone who is defamation proof. Like, for example, Adolf of 1940s Germany fame. Could I defame him? Let's say he was alive today. Let's say that Earl wasn't successfully hunting Nazis in South America in the 80s. And let's say that Adolf survived and was alive today. Could you defame him? Could you say, you're an anti-Semite? Why could you destroy his reputation anymore? Could you? So There is a class of people out there who are defamation proof. Jeffrey Dahmer. Could you defame Jeffrey Dahmer? Could you defame Timothy McVeigh? That's a valid question, you know? Could you defame this person? That's going to be something. And also, we need to establish the actual malice standard, because Chile seems to be ignoring the fact that he's a public figure. He's a public figure. So he actually has to prove that the defendants acted either knowing it was false or with reckless disregard as to whether it was true or false. He has to establish that. And he hasn't done that yet. So, I mean, good luck, Chuck. I will also proceed to my earlier motion for sanctions for spoliation, which was denied, and the jury instruction for that, as well as jury instructions appropriate for the unavailability of out-of-state witnesses that the defense will struggle to produce due to its defamatory case allegedly involving Los Angeles witnesses. You don't know who the defense is calling, so I don't know what you're on about there. I have yet to amend my complaint, and it could easily be amended to dismiss my action. Oh, could it? The problem is that there are counterclaims against you, so good luck. And it would break precedent to try to sanction or find a pro se filer in contempt for doing so. You telling the court that you're going to do something, if the court thinks that you shouldn't do it, and you're like, oh, I'm going to do this, and it would break precedent for you to find me in contempt for doing it, despite you not wanting me to do it. Especially in the interest of justice. Again, he says it, he doesn't show it. Additionally, the responses provided are obviously hastily prepared and not a great loss, as the counterclaims, I think, will not survive even the simplest attacks on jurisdiction. Oh, good luck. Why don't you just attack them then? So you're actually undermining your argument, because all you have to do now, according to you, is just attack their jurisdiction and they go away. So why don't you just do that, Chile? Since the answers were just filed and lack any substance, that's again a conclusion. The court is not invested in this case. Again, that's a conclusion. That's not a fact. It will save the defendants time and money for this action to be dismissed rather than proceed only to lose on appeal later. Jesus Christ. So with that in mind, I pray for the court in the interest of justice and the aforementioned reasons to investigate and locate the missing NVD filing and correct the record, but alternatively to transfer venue, grant a preliminary injunction. I declare under penalty of perjury the foregoing is true and correct. And he's requested an oral argument. Oh, nice. Oh, that'll be fun. That will be fun. And then we have this. This is apparently his motion to dismiss. He shows it. This is his document. He shows it was created at 11/5/2022, modified same time. So it's created and modified at the same date, which means that he probably downloaded it from someone else. And awesome. You know what? You can change the date on your computer and download a file, and it will show that date. Just so you know. This is the some of the stuff showing that he went to ecf.mad.us.courts, and then he spent a bunch of time in YouTube studios for about 20 minutes. Okay. These are all going to be emails, so we're going to go down to the bottom and work our way up to the top. 3 attachments: Google history, video testimony withdrawn, motion to dismiss. So this is to the clerk of the court. To the clerk of the court, Caitlin McClurk McManus. Somehow I doubt her middle name is McClurk. I filed this notice of motion for voluntary dismissal. What is a notice of motion for voluntary dismissal? He filed a motion to dismiss. Okay, so he filed a motion to dismiss. on Sunday. So not only did he file, wait, oh, he's calling his notice of voluntary dismissal a motion. Okay. Here's a metadata from Google Chrome. The notice of voluntary dismissal is not showing up on Pacer, and the time of the filing of the critical. Time of the filing is critical. Can you please let me know what's going on? Why isn't it showing up? Thank you. So he sent this on November 8th. Well, we'll call it November 7th because it's in the morning. I think that's after he got off his live stream and figured out that that they had filed answers and his stuff wasn't showing up. So Caitlin McClurk McManus said at 12:57 p.m., "Sorry, I missed your call. I am looking into this. Did you get any email notices when you attempted to file your notice? Please be patient. I'll let you know when we have more information in response to your inquiry." Dear Mr. Decastro, a colleague has checked for me and said you do not have any Pacer transactions for the month of November. Oh no. The only thing I can suggest that you do is try again. If you successfully file anything, you will get an electronic notice of filing by email right away that will serve as your confirmation. Oh, it's right away. That's my understanding of it. And this was November 8th, again at 3:57 p.m. So as of November 8th, 3:57, he should have known. And then he waits till that evening and says, well, then it didn't work. Perhaps I made an error. Perhaps you did, Chili. Perhaps you did. As you could see, he says, from the Google metadata, I thought I did it. I created a video testimonial right after I submitted it to the voluntary notice of withdrawal. As you can see, the notice is dated November 5th. I hope this can work out. Yeah, you're asking the clerk to what? To falsify things? That's kind of weird. And then this is to Joshua Garrick. This is Abrams' attorney. Mr. Decastro, show hidden text. I don't see. Okay, no problem. Show. Okay. Quote hidden text. Okay. Mr. Garrick, this is not service. As we have been clear, we're not accepting service via email. Sorry, bro. Good luck. The judges rule we do not need to confer with you before we file. We'll see how it shakes out. Yeah, I guess we will. And then quote hidden text, blah, sent from my iPhone, blah. And then this is from Joshua Garrick. Mr. Decastro, since your notice of dismissal was not properly served, it is ineffective and you could only dismiss FRCP Rule 5. What did Chili do? The parties represented by attorney service under this rule must be on the attorney unless the court, blah, blah, blah. By handing it to the person, leaving it, yada, yada, mailing it, leaving it, sending it. Sending it to a user. So I think where Chili, where Josh's attorney is doing this, is that he wants it ECF now, or by other electronic means that the person consented to in writing. So he's not accepting it via email, I guess. Which, I mean, turnabout's fair play. If Chili's being a dick, then I guess Josh Garrick can be a dick. It is ineffective, and you can only dismiss the claims now with a stipulation of dismissal signed by all parties, or by court order. Mr. Abrams would agree to dismissal if you dismiss claims as to him with prejudice. Good on you, Josh. While you would be abandoning claims against Mr. Abrams, that will leave you free to pursue claims against Ms. Peter, who I suspect is a person you really have an axe to grind with here. Let me know if you agree, and we could file a stipulation of dismissal without delay. And then I guess that's the end of it, or is this part of it? So this is to Mr. Wish, but he's sending this to Josh Garrick and appliedautism@gmail.com. Mark Adams, website Adams. Mark Adams, website Adams, appliedautism@gmail.com. I don't know who that is. I'm sure some autist out there will figure out who that is. So he calls Joshua Garrick Mr. Wish, which is nice. I'm pleased to get to know the way you are and who you are, snake in grass, blood-sucking lawyer. You're a real scumbag. Good luck at Heaven's Gate. Jose M. Decastro. Wow, that's a pleasant little email exchange there. I'm sure the court's going to love to read that. Oh, did he actually send it to the wrong Josh? This is just a draft, okay. So November 7th at 1:43 p.m. is where the start of this email exchange went. Okay. I'm getting it. So it looks like he sent it to Josh Abrams. Yeah, he sent it to the wrong Josh. Uh-oh. Uh-oh. He didn't serve it on the attorney of record. Uh-oh. I was saying this to you and I accidentally said it to Josh. Forgive me my error. There is a certain point at which errors stop being forgiven, Chili. And then, I don't know what this is. One of five, that was 2-5. All right. And then, so Chili apparently said something regarding we have set specific stipulations. Please see that you follow them or you may face future litigation. Jose M. Decastro. Wish says, Mr. Castro, what stipulations are you referring to? We've not stipulated anything. Oh, here we got discussing law. Nice. Discussing law at gmail.com. Huh. That's what the problem was. He sent to Josh Abrams accountability for all except Josh Garrick. You suck. So that was the motion to dismiss, and we've set specific. Okay. All right, so that's the first one. Lord, this is probably hours long already. So this is the second one. So it's still the same. Let's go up. I don't want to double anything. Support of this motion, memorandum support. NVD appear on. NVD appear on. I'm treating it as UI. I'm treating it as IU. Right to file this. Right to file this. If I lose on the merits. If I lose on the merits. Locate the missing NVD. Locate the missing NVD. These all appear to be the same so far. Exhibit 1 is the same. I guess he hadn't marked Exhibit 2. So he marked this one Exhibit 2, okay. And Exhibit 3 is his email to Josh Abrams, not Josh Garrick, and Benjamin Wish. And then Exhibit 4 is starting off with okay, so this is a new Josh Garrick one. So he says it was not properly served, but it doesn't matter because it's filing, not service. It's important, pursuant to FRCP 41. Remember, you have can dismiss an action without a court order by filing, not serving, filing a notice of dismissal. So that's a with prejudice. Page 2. Okay. So he cleaned up some of the... I accidentally sent it to Josh. Just mistakes were made. All right. So I hope you are now fully aware of what's going on. Thanks for watching. Have a great day.